And now we're moving to our next speaker, Maureen O'Hara. Maureen is going to explain her last article called Gender Identity Theories Capture of Criminal Justice Institutions in England and Wales, which is descriptive enough. And I said it's our very own Maureen O'Hara because she's a co-author of the declaration. She's a legal academic and feminist activist living in England, and she's currently researching the impact of gender identity ideology on the criminal justice system in England and Wales. So welcome, Maureen, over to you.
I'm going to be focusing on England and Wales because there are 3 separate jurisdictions in the UK, and they're all slightly different in relation to some of their laws, at least, although there are some common pieces of legislation as well. And as Amparo said, I'm basing my talk on a publication that I recently wrote for the think tank Policy Exchange, which looks at transgenderism and policy capture in the criminal justice system. It looks at 4 key services: the police, the Crown Prosecution Service, who are the state prosecutor in England and Wales, the courts, and the prison service. And you can download it from Policy Exchange's website. It's free to download if you want to look at it. I spoke about what's happening with the courts in a WDI seminar earlier this year, and I also talked about the Crown Prosecution Service, or CPS, to some extent as well. So today I'm going to focus on the police and on the prison service mainly. I say a little bit about the law in England and Wales, and in fact this is UK-wide, what I'm going to say now. There's the Gender Recognition Act 2004 makes provisions enabling individuals to obtain a gender recognition certificate, which changes their gender or sex. The legislation is very ambiguous about which it's talking about, for most purposes, but not for all purposes. And they have to meet certain criteria specified in the Act in order to obtain a gender recognition certificate. Self-declaration of gender identity hasn't been incorporated into law in England and Wales, and the government have expressly said in 2020 that they weren't going to incorporate it after a public consultation about it. But in recent years, self-declaration of gender identity, so-called, has been adopted as policy by all of the key criminal justice institutions, even though it's not aligned with the law. And they now all effectively subscribe to the ideological belief that individuals' subjective sense of gender identity should take precedence over their biological sex. The adoption by criminal justice institutions of this belief appears to have come about largely as a result of policy capture, because it's not aligned with the law and it's been adopted without any public scrutiny or consultation with the public. Now, that isn't to say that the GRA isn't a problem in and of itself, but any system which treats men as if they're women undermines women's sex-based rights. But self-declaration of gender identity creates additional problems and makes the overall situation much worse. Trans-identifying male suspects and convicted offenders are now being recorded as female by the police and the Crown Prosecution Service. Their preferred pronouns are being used in court, and some are being housed in women's prisons when they're convicted of crimes. And that matters because sex is a key factor in criminality, and particularly in relation to sexual and violent offences, the overwhelming majority of which are committed by men. It's impossible to understand the nature of sexual and violent crime without understanding the ways in which it's shaped by the wider social context of power relationships between the sexes. And accurate information about the sex of suspects and offenders is crucial to the development of law and policy aimed at reducing and trying to prevent sexual and violent crime at a societal level. And it's also crucial to the identification, investigation, and prosecution of sexual and violent crime at an individual level. The acknowledgement of the significance of biological sex is also crucial to the safety, dignity and privacy of female prisoners and detainees. And by detainees, I mean women who are detained by the police service while they're investigating crimes. So to illustrate what I'm saying about sex being a key factor in criminality is probably not news to anybody here, but I'm just going to talk a little bit about male patterns of offending as identified in England and Wales by state organisations. And this is a quotation from Jo Phoenix, who's a professor of criminology. And she says that sex is the single strongest predictor of criminality and criminalisation. Since criminal statistics were first collected in the mid-1850s, males make up around 80% of those arrested, prosecuted and convicted of crime. Violent crime is most commonly committed by males. This remains the case regardless of stated gender identity. And Ministry of Justice figures support that. They published figures in 2020 which showed that 98% of those prosecuted for sexual offences in England and Wales in 2019 were male. And Ministry of Justice data published in 2019 found that 98% of those convicted for sexual offences against children in 2017 were males. Now those kinds of percentages can be seen in all of the research. They vary to some extent, but always the percentage of sex offenders, whether it's against adults or against children who are male, are in the 90s and usually the high 90s in any research that I've looked at. A significant majority of those prosecuted for non-sexual forms of offences against the person are also men. And data published by the Office for National Statistics in 2021 for the 3-year period ending in March 2020 showed that 93% of those convicted of homicide were male. In England and Wales overall, males generally make up 95% of the prison population. So they're overwhelmingly the perpetrators of criminal offences, particularly violent and sexual offences. And the kinds of offences women tend to commit largely are much less serious offences against property, shoplifting, relatively minor offences. The majority of those who were sexually assaulted are female. And for the year ending March 20, the Crime Survey for England and Wales estimated that 618,000 women and 155,000 men aged 16 to 74 had experienced sexual assault, including attempted sexual assault in the previous year. That's a prevalence rate of 3 in 100 women and 1 in 100 men. Now they could well be underestimates. I generally thought that the amount of sexual violence that is occurring is underestimated by most of the measures of it. In research published in 2021, Karika Kastner and Professor Liz Kelly estimated that 15% of girls and 5% of boys experience some form of sexual abuse before the age of 16. And that sexual abuse, as the previous figures show, is overwhelmingly committed by males. And the picture is no different in relation to trans-identifying males. So figures presented by the Ministry of Justice in the case of Crown on the application of FDJ and Secretary of State for Justice, which I'll talk about a bit more later, suggested that data collected across the prison estate in March-April 2019 showed that 46.69% of trans-identifying male prisoners had convictions for sexual offences. By comparison, data for 2020 showed that fewer than 20% of male prisoners in the general male prison population were serving sentences for sexual offences. And on 14th of January 2022, the Justice Minister, Victoria Atkins, replied to a parliamentary question, and her reply indicated that the proportion of trans-identifying males in the prison estate who were currently serving sentences for sexual offences was in the region of 60%. The figures weren't precise because the Ministry of Justice wasn't certain how many trans-identifying males held in the women's estate at the time had convictions for sexual offences, but they believed it was fewer than 5. One of the reasons their figures are not accurate is because they don't keep accurate and detailed records of those with a GRC, Gender Recognition Certificate. So the majority of trans-identifying sex offenders are held in the male estate, but some are held in the female estate, and that varies at different points in time. There's a range of possible explanations for the high proportion of trans-identifying male offenders who've committed sexual offences. Those figures don't necessarily indicate that they are more likely to commit sexual offences than other males, generally, we don't know. But they do clearly indicate that many trans-identifying males retain male patterns of criminality. So that's one of the reasons why it's important not to record them as female in crime statistics. Current police guidance on the recording of sex and gender says that where there's doubt as to whether a person should be treated as being male or female, that person should be asked to indicate their preference and treated in accordance with that preference, except where there are grounds to believe that the expressed preference doesn't accurately reflect their predominant lifestyle. So if a man who was, in the eyes of the police, living as a male, wearing male clothes, using a male name, just before being arrested, for example, and there was evidence of that said he was female, they might nevertheless record him as a male because they wouldn't regard him as living as a woman. If they did regard him as living as a woman because of his dress or the name that he used, or whatever else it might be, they would record him as female according to his preference. And the person's gender, as established under this guidance, must be recorded in their custody record. So the data recorded by individual police forces affects data recording within the whole of the criminal justice system because it gets transferred onto other data management systems. And misleading data created by police forces is particularly concerning in relation to the recording of data about offences which are predominantly committed by biological males, violent and sexual offences. Inaccurate data about patterns of sexual and violent offending creates a significant impediment to the development of effective law and policy aimed at the elimination of violence against women and girls. The Crown Prosecution Service approach to the recording of so-called gender identity is essentially the same as the police approach. And the result of that is that increasingly rapists are being recorded as being women. The offence of rape in English law can only be committed by a male because it involves penetration with a penis without consent. So it cannot be committed by a woman. But it's being recorded as having been committed by women by both the police and the Crown Prosecution Service. And CPS data published by the Office for National Statistics in 2018 showed that between 2012 and 2018, a total of 436 people, i.e. men, who were prosecuted for rape were recorded as women. And the proportion of rape defendants classified as women during this 7-year period varied between 1.2% and 1.8% for each of those years. Recently, in April this year, the Home Office proposed a new policy on police recording of data about suspects and victims of crime, and said that they should be recorded on the basis of their sex as recorded on their birth certificate, or on the basis of their sex as recorded on their gender recognition certificate. And that gender identity, where someone doesn't have a gender recognition certificate, should be recorded separately if that is different from their biological sex or their legal sex, which is, if they have a GRC, it would be generally referred to as their legal sex. If that new approach becomes standardised at a national level, police forces will be required to record trans-identifying male suspects and offenders who have a GRC as women, and they'll lose the discretion that they currently have to record their biological sex. Individual police forces at the moment have a lot of discretion. They operate quite differently from each other in some respects. If that happens, then misleading data will continue to be produced by police forces, and not only that, but their data will be replicated in other criminal justice data. Another new recent development relates to police searching policy, specifically the searching of detainees held by the police by trans-identifying police officers. A new policy was published in December last year, but it wasn't made public. And this is the essence of the policy, which says employers, by which they mean the police force, should treat people in accordance with their lived gender identity, whether or not they have a GRC, and should not ask transgender colleagues if they have a GRC or new birth certificate. Accordingly, with regards to the issue of searching, chief officers are advised to recognise the status of transgender colleagues from the moment they transition, considered to be the point at which they present in the gender with which they identify. Thus, once a transgender colleague has transitioned, they will search persons of the same gender as their own lived gender. And this policy states that this applies to strip searches, which are searches involving the removal of clothing other than outer clothing. For example, when police officers are looking for a weapon or something else they're searching for, and intimate searches. Intimate searches are very rarely carried out by police officers. They're usually carried out by medical professionals, but police officers do carry them out, and what they involve is examination of bodily orifices. So this policy is saying that trans-identified police officers can search female detainees and can carry out both strip searches and intimate searches on female detainees. The Police and Criminal Evidence Act and its codes of practice, which govern police conduct in most areas, specifically say that any search involving the removal of more than outer clothing should be made by an officer of the same sex as the person being searched. And that search may not be made in the presence of anyone of the opposite sex unless the detainee specifically requests that another person should be there who is of the other sex. The new policy, which would allow males to carry out strip searches and intimate searches, was not made public, as I've said. It only came to light following research by Kathy Larkman, who's a retired police superintendent, and she wrote to the College of Policing, the Police Federation and the National Police Chiefs Council in December last year, asking for clarification about the searching policy in relation to trans-identifying police officers. She eventually received a copy of this policy in April this year, and she passed it on to a national newspaper. I read about it in that newspaper and I obtained it from a journalist at the paper. It has not been made public. I can't find it on any police websites. So it's been brought in under the radar, and it allows trans-identifying males to search women intimately and to carry out strip searches. And according to the policy document, that's already policy in some police forces. If a woman refuses to be searched by a trans-identifying male, the police force will generally ask someone else to carry out the search. However, the policy says, if the person being searched objects to being searched by any colleague, it may be advisable for them to be replaced by another team member to search that person. This is regularly done in practice, regardless of the reasons for objection, to de-escalate any potential conflict. If the refusal is based on discriminatory views, consideration should be given for the incident to be recorded as a non-crime hate incident unless the circumstances amount to a recordable crime. A non-crime hate incident is an incident which is subjectively perceived by the victim or any other person as motivated wholly or partly by hostility or prejudice towards a particular social group, but which doesn't amount to a criminal offence. They're recorded by the police, and the records are kept by the police. There's no consideration in the policy of the potentially traumatic effects on a female detainee of being strip searched or intimately searched by a male police officer. No mention is made of the rights to safety, privacy, or dignity of the detainees involved, and the only potential motivation for objecting to such a search, which the National Police Chiefs Council recognise, is the holding of what they call discriminatory views. Where a person who is not authorised to carry out a search on a suspect under the provisions of the Police and Criminal Evidence Act does so, that amounts to assault or battery in law. It's a criminal offence. And where the search is a strip search or intimate search, it can amount to a sexual assault. The extent to which someone detained by the police could give valid consent to this kind of search is questionable under any circumstances because of the power differentials involved in that situation. But free and informed consent could clearly not be given in circumstances where the police can record the refusal to be searched by a trans-identifying male as a non-crime hate incident. The NPCC guidance amounts to the police instituting a practice which would normally constitute sexual assault. And arguably, it could constitute degrading treatment, contrary to Article 3 of the European Convention on Human Rights. Article 3 is an absolute right, should never be contravened in any circumstances, as well as a violation of detainees' rights to privacy and private life under Article 8. It's clear from the way the policy document is written that the NPCC are aware that it's open to legal challenge, which is presumably why they tried to keep it hidden from the public. I was shocked when I read it after seeing the article about it in the newspaper. I was really shocked by it. The prison service searching policy, in relation to prisoners with the GRC, so trans-identifying males with the GRC, must be searched in accordance with their acquired gender, regardless of their bodily characteristics, unless they prefer otherwise. And some do, and some reach an agreement otherwise. But what that policy means is that female prison officers are required to search trans-identifying males who have a GRC, some of whom are sex offenders and some of whom retain male genitalia, and may well be aroused by the search. Currently, trans-identifying male prisoners are not permitted to search female prisoners, and that includes prison officers who have a GRC. But the prison service is considering changing this policy to enable prison officers with a GRC to search prisoners of their acquired gender. In other words, to search women prisoners. And intimate searches are much more common in prisons than they are in use against detainees in the police station. So it raises the same issues as the police searching policy. The fact that they have a GRC will make no difference to female prisoners' experience of the search. As I said, some trans-identifying males are housed in the female prison estate, not all of them. The policy is that all prisoners are initially allocated to the part of the prison estate which corresponds with their legal gender. So those with the GRC are initially allocated to the women's prisons. Subject to the approval of a complex case board who conduct risk assessments, prisoners who identify as transgender but don't hold a GRC may be placed in the part of the estate which corresponds to their self-declared gender identity, in other words, be placed in the female prison estate. A trans-identifying prisoner with a GRC who is biologically male must be placed in the female estate, except for exceptional circumstances, when they can be placed in the male prison estate where they're held separately from other prisoners. The exceptional circumstances would usually be where they represent a very high degree of risk to female prisoners if they were to be housed in the female estate. But the policy doesn't state that a previous history of sexual offending against women is an exceptional circumstance for this purpose. And in practice, trans-identifying male sex offenders with and without GRCs are placed in women's prisons. In 2021, this policy was challenged in the case of FDJ, versus Secretary of State for Justice, which I mentioned earlier. And the claimant was a woman who said she'd been sexually assaulted by a trans-identifying male prisoner with a GRC while she was held in Bronzefield Women's Prison. And she based her claim on 2 grounds. The first was that the policies are unlawful because they indirectly discriminate against women, contrary to Article 14 of the European Convention, which prohibits discrimination, along with Article 3, which is the prohibition of torture and inhuman and degrading treatment, and or Article 8, which is the right to respect for private and family life. And the second ground was essentially that in formulating the policies, the Ministry of Justice had failed to take account of the provisions in the Equality Act 2010, which enable single-sex spaces to exclude all males, including trans-identifying males with a GRC, provided that the exclusion pursues a legitimate aim and does so in a proportionate way. And FDJ argued that that is the policy that the prison service should institute, and not doing so is discriminatory against female prisoners. The claim failed, and the court found that the prison service is not required to apply the Equality Act exceptions. And they also said that the policy was lawful essentially because it requires risk assessments to be made when deciding where trans-identifying male prisoners are going to be placed. This is what the judge said. This is the leading judgment. Lord Justice Holroyd said, "I readily accept the proposition that some and perhaps many women prisoners may suffer fear and acute anxiety if required to share prison accommodation and facilities with a transgender woman who has male genitalia, and that their fear and anxiety may be increased if that transgender woman has been convicted of sexual or violent offences against women. I accept Ms. Monaghan's submissions," she was the advocate for FDJ, "that the taking by the defendant of steps which increase the risk of Article 3 mistreatment of women prisoners is within the ambit of Article 3. However, the subjective concerns of women prisoners are not the only concerns which the defendant had to consider in developing the policies. He also had to take into account the rights of transgender women in the prison system." The judge didn't explain precisely what these rights of trans-identifying prisoners are, but it can probably be assumed he meant what he went on to call their right to live in their chosen gender. When women are incarcerated with biological males who have already been convicted of committing sexual offences, their fear of sexual assault is objectively justifiable. And this characterisation of their fears as subjective trivialises them and frames them as objectively lesser concerns than concerns about the rights of trans-identifying male prisoners. He didn't explain exactly what the right to live in their chosen gender consists of, or precisely why they needed to be placed in women's prisons in order to exercise this right. Trans-identifying males who are held in men's prisons are held separately from other men, and they're treated in accordance with the women's prison regime. So, for example, they can wear women's clothes and makeup and so forth. And all male offenders who identify as transgender could potentially be held in the male estate in this way, or they could be housed in specialist units without female prisoners being put at risk of sexual assault and experiencing the fear and anxiety associated with that risk. What prevents this appears to be the perceived need for women prisoners to validate the gender identity of trans-identifying males. And that's a theme throughout the judgment. Unlike biological sex, as we all know, gender identity is essentially performative. We retain our biological sex regardless of the clothes we wear or the adornments we wear or the people we're associating with. We just are male or female. But the performance of gender identity requires an audience. And an audience of women appears to be perceived as more validating than an audience of other trans-identifying males, because they could perform their gender identity with each other, but that doesn't seem to be sufficient. They need, in the view of the court, and they need, in the view of the Ministry of Justice, to be placed with women in order for their to be able to affirm their gender identity. The claimant in this case, who in a newspaper article went by the name of Amy Jones, was interviewed about her experiences in prison shortly after the judgment. She was out of prison by that time. And she said that while still in prison, she was transferred from Bronzefield to Downview Women's Prison and discovered that Jay, the person she alleged sexually assaulted her when she was in Bronzefield, had also been transferred there. Jay was in E-Wing, which is a special unit for trans-identifying males who are assessed as too dangerous to women to be housed in the main women's prison, but were not seen as meeting the criteria for allocation to a men's prison. So they have a separate unit, but they have specified times when they mix with female prisoners, which is supposed to take place under supervision. And she said about this, "I felt like I'd been punched in the stomach. They moved me for my own protection, and then I ended up back in the same prison as this person who had sexually assaulted me. Quite a few women were scared of Jay because she would rub up against them in the dinner queue with an erect penis. She would wear very tight trousers, which made it obvious she had male genitalia. The prison officers protected her more than they did us. They were terrified of being accused of transphobia." And that sort of behaviour by trans-identifying males, drawing attention to their penis, walking around with erect penises, walking around naked, making sure women see them in showers, etc., has been described by a lot of female prisoners and also by former prison governors who've observed it as well. Another issue, and this is one which affects women's ability to talk about their experiences of sexual assault and the imposition by male prisoners on women, which are behaviours which are not directly assault, but which are designed to intimidate them, is the compelled use of preferred pronouns. Female prisoners are punished if they use male pronouns for trans-identifying male prisoners. This is a quote from the Justice Minister, Lord Wolfson, who says that incidents where a prisoner uses incorrect pronouns for another prisoner will be considered on a case-by-case basis. If an officer deems it appropriate to place a prisoner on report, the rule against using threatening, abusive or insulting words or behaviour may apply. An offence motivated by another person's protected characteristic under the Equality Act, gender reassignment is a protected characteristic, is an aggravating factor and may merit referral to an independent adjudicator. Under prison discipline policy, cases are only referred to an independent adjudicator who has to be a district judge or a deputy district judge if it's thought that if the person is found guilty, additional days in prison may be ordered. So what this amounts to is the imposition of criminal penalties for misgendering, which is not a criminal offence. It's compelled speech in its most authoritarian form in this jurisdiction. And as with the compelled use of preferred pronouns in court, its imposition in prisons can have the effect of hindering women's ability to describe assaults because it robs them of the language with which to do so. This is a quotation from Kate Coleman, who runs the organisation Keep Prisons Single Sex, about an interview that she carried out with a former female prisoner. And she said, "She told me that female offenders generally don't complain because there's simply no point. If a woman did make a complaint about the actions of a male prisoner, she would have to use female pronouns. But it wasn't a woman who was aggressive to her or threatened her or assaulted her or showed her his penis. It just wasn't. The language she's compelled to use means that she is forced to describe an incident that involved a woman. She is forced to agree that this prisoner is a woman, is female." So the case of FDJ didn't succeed in changing the policy. There have been a number of attempts to change the policy in Parliament. And during the recent passage of the Police, Crime, Sentencing and Courts Bill, there were two amendments tabled designed to change the policy. Both of them failed. However, the Prime Minister, in an interview in April, said women should have spaces, whether it's in hospital or prisons or changing rooms, which are dedicated to women. It remains to be seen whether these comments result in any action. Ministers frequently make these type of comments and nothing comes of them. But currently, policies within the criminal justice institutions which treat biological males as if they're women are causing harm to victims of crime, to some of the staff working in criminal justice institutions, and to female detainees and prisoners. They're rooted in an extreme ideology in which claims to rights based on gender identity take precedence over the rights of others, and particularly the sex-based rights of women, even where this involves denying women's rights to safety. Most of these policies are not aligned with the law and have developed in the absence of public scrutiny or democratic consensus. Some of those which are aligned with the law, such as the requirement that female police and prison officers must carry out searches of males with a GRC, demonstrate a fundamental tension between women's sex-based rights to safety, dignity and privacy, and the rights conferred on trans-identifying males by GRC. So as I said earlier, the GRC is creating part of the problem, but more widely, the adoption by all of these agencies of self-declaration of gender identity is creating a number of problems which could be solved without a change in the law, which isn't likely at the moment, if they stopped applying self-declaration. It wouldn't solve the problems created by the GRC, or by the GRA, I should say, but it would solve a lot of the problems that are currently taking place and the ways in which women's sex-based rights are being undermined by criminal justice agencies. Thank you.